After I accepted the guilty plea in this matter, ordered that a pre-sentence investigation report be prepared. I have received that report and reviewed it. A copy has also been provided to your attorney. So let me first ask Mr. Smith, or Mr. Swanson, you had a chance to review that pre-sentence investigation report?
Yes.
Mr. Smith, are there any parts of that report that need to be clarified or corrected?
Your Honor, there are not. There are some arguments we will make a paragraph at a time, but no changes to be made.
Mr. Swanson, you wish to stand by the plea of guilty previously in this case?
Yes.
Are there going to be witnesses on behalf of the defendant?
Judge, there won't. My argument might be a little longer than normal, but no witnesses.
The court has reviewed the letters of support that were attached, and I have reviewed and considered those, and we'll consider those as part of that.
Thank you.
Any witnesses or victim impact statement by the state?
No, Your Honor.
All right, Mr. Smith, for our now sentence this matter, I'll let you argue on the client's behalf. You can remain seated.
I was going to say, Your Honor, yes, thank you. You know me well enough to know I usually like to stand, but I know Madam Reporter needs to get a good record, so thank you. Judge, this is a case that's very hard for me because the young man sitting next to me is somebody who I've coached, who I've known for a lot of his life. His parents are good friends and excellent people in this community who I've watched serve our community in more amazing ways than I could even begin to count today. Their other children are as fantastic as the young man sitting next to me. They've contributed to our community. They've served their country in the military. They've done amazing things, and I think on any given day, any member of the community that knows the Swanson family, the way I know them, would show up and give them the thanks that they deserve. But it doesn't change the fact that we're here today for something that Teagan has had to take responsibility for. And he's done that. And Judge, I want to point out a few things about the acceptance of responsibility, because I'm going to talk to the court about some small nuances that sometimes can lead to some misunderstanding with maybe someone in the community or a prosecutor's office or even a court to think that maybe I'm somehow splitting hairs about things that we shouldn't be. And I will highlight those for the court. I think this court knows me well enough to know that we genuinely want this court to know and understand that he has accepted responsibility, but there's a few things we want to point out that we think will make a difference. With that in mind, let me just indicate to the court that you have had a chance to review the letters, you've reviewed the psychosexual evaluation, you've reviewed the polygraph. The polygraph and psychosexual evaluation were done voluntarily and very early on by my client to give the prosecutor and ultimately this court important information about him and about what we hope will satisfy the court on some issues with regard to the four related goals that this court has to consider with sentencing. My client cooperated with law enforcement. He was honest with law enforcement. You might note from one of the notes in the police report, and maybe it was in the PSI, that, you know, initially when he was just taken in for the first few minutes, I think he was startled, and I think it took him a few minutes, but it didn't take very long before he was honest about all of that. And Judge, we know this because once he did the psychosexual evaluation and once he took the polygraph, it came back completely clean. Judge, I got thinking about the percentage of cases that I've had where a polygraph has come back completely truthful. And it doesn't happen very often. This court's heard me make many arguments about the fact that there are a lot of reasons why that can happen. And sometimes it's not as bad as it may seem. Sometimes things can happen that lead to deceptive results on a polygraph or things that are not completely clear or certain. But in Teagan's, it was always clear and certain because he was always upfront and honest with law enforcement. He was then upfront and honest with his parents. He was upfront and honest with Dr. Lasota, who did and performed the psychosexual evaluation. And I think that's an important starting point for us all to recognize that once this came to light, he has done nothing but accept responsibility. He moved forward without contested preliminary hearings and putting the state to the test of their burden or evidence, and he has consistently been successful at his pretrial release. We received the report that the court has There was one little blip there, which they found out was actually someone else in the home that was accessing games. It was not Teagan, and there was nothing illegal about the access that had occurred in the home. Other than that they had to confirm, he has been on that pretrial release since back in February of 2022 and done very, very well in the community. He is getting counseling through RHS. He's been proactive to do that. Judge, one of the things that I want to point out, and maybe this is the time to do that, and it's in conjunction with how this case came about, is a mental health component here that's very important. So with a little bit of indulgence of the court and with me giving a highlight to the court that the little nuances that I'm about to explain don't in any way try to preclude responsibility or the serious nature of this crime. However, this young man is different in so many ways from so many other cases that I've had, including some in front of this court in the last couple of years that were hard cases, and I know that the court had to put a lot of thought into what happened in those cases. But there's some differences, and I'm going to point those out. The Kick application that my client had on his phone that these images came through is actually an application that many of us have on our phone and like to have on our phone because it's a way to communicate with friends and family. It's not on the dark side of the web. It's not one of those apps that you've probably read and heard about so many times in these reports where somebody accesses something that they recognize that they can get illegal materials on. In fact, the Kick app that my client started was activated on November in 2021. For a long period of time, the only thing that's on that app that my client was accessing is two groups, a car group and a motorcycle group. All good proactive things that we would encourage our young adults to be involved in. That lasted on that application clear through until April 2nd of 2022. It wasn't until April 2nd of 2022 where someone within that group sent my client an invitation which he accepted. The invitation wasn't sent and said, hey, you can access pornography or something bad here. It was just an invitation from somebody who was in one of these other two groups. My client frankly didn't think that there was anything wrong with that and accepted that, that invitation. It wasn't long after that where the mistake was made, and when I say mistake, I mean the responsibility that we've talked about. My client violated the law, he knows that, but for him, it was the first mistake that he's ever made in his life like this. He has a completely clean criminal record. He'd had nothing up until this point that he'd ever done that had been suspect, not with his family, not with school administrators, not with the people whose letters you've read, not with any of us. But on that time, somebody sent to him some pornographic material that was not just of acts depicting child abuse or child exploitation. There was some pornographic material that he uploaded, and as that uploaded information was there, there were 4 videos of child pornography. He saw that, he recognized it, it was there, it was uploaded to his phone, he had seen it, he's accepted responsibility for that. There is no doubt about that. What I'm trying to emphasize is that he was on a good app, not on the dark side of the web. He did no search engines to find this. There was nothing that he sought out. He was dealing with people who were talking about cars and motorcycles until that invite came and until the download happened on April 2nd of 1922, or 2022. This is all confirmed in the reports that we have and in the discovery. That account was then suspended May 3rd of 2022. So 1 month later, approximately, it was suspended because this app that many of us have, which is a good app, determined that there was some illegal activity that was happening and the account was suspended. Now, here's what I'm also going to point out. At this point, we're now in May of 2022. My client is not arrested for what was downloaded on his phone until February of 2023. Between May and February, what did my client do? He did not access any different devices. He did not access any different web places. He did not go to the dark web. He had the images that you're aware of in here, and I think that there's a number that they put at 158 in the 4 videos. That is all corralled in what I've described to you, which was the download that came with some other materials that also were not illegal materials from that invite on May 3rd of 2022. But once the account was suspended, he still had, I guess, access to that. I'm not trying to be disingenuous with any parlor games here, but he did not go out and actively seek, search for, or obtain anything other than that. This is unique. I've done hundreds of these cases over the last 10 years, and I've never once not seen there being more activity of someone when they've done this or accessed it, go different routes to find it, or to trade it, or to find ways to get it. And my client did not do that. So we know what we have, we know what we're dealing with, and we know that we have somebody that from May 3rd, when he had no idea that law enforcement was even looking at this, until his arrest of February of 2023, where he goes and does not access any other materials. I think that's an important distinction. And then let me make the other important distinction to tie this together. If you look at Dr. Lesoto's report, he says under amenability for treatment, and I'll just read from the report. I don't think that there's page numbers, Judge, but you kind of know where the amenability for treatment is. It's towards the end. I'm going to read directly from the report. It appears most likely that Mr. Swanson's paraphilic disorders are a function of a severe anxiety depression disorder which began at approximately age 12. The level of impairment was significant enough to disrupt normal adolescent sexual development, and as a result, he has never engaged in age-appropriate sexual activities despite his sexual interests strongly leaning toward a normal male heterosexual. This mood disorders may or may not have an organic etiology. Given his history, it is quite possible that a post-concussive syndrome may have initiated and been driven or driving this mood issue. Judge, here's what we want to let the court know. My client made decisions at a younger age to do pro activities. He played a lot of sports. He suffered a lot of concussions. He suffered concussions around that age. His parents and I have talked and looked at and seen medical records about the concussions that he experienced. Approximately 3.5 years ago, he experienced a BMX bike concussion that was again very serious and probably more serious because of the concussions he had at a younger age. Dr. Lesoto has given us some answers here, and he's been careful. This is why I think you can trust his report. He said, listen, some things can happen organically that cause this maturation to not occur in a normal fashion. But there is no doubt, I think, in his mind that the concussions that were suffered and the ongoing concussion about 3.5 years ago really led to this depression and anxiety, which then led to where we are today with this decision-making process. Now, I want to deal with this for a minute because here's why that's important. This court's well aware that the developing brain, typically in a younger person, happens in the mid to late 20s. Scientists and doctors put the age at approximately 27 years old for complete brain development. When you suffer concussions and things like that, especially to the frontal cortex is the area of the brain where we make decisions, where hopefully we make good decisions, but that's where that is affected. And in talking to Dr. Lesoto, obviously those concussions and this delay in him having this normal adolescent situation, in part because of the concussions, can lead to poor decision making. Dr. Lesoto, with parents that were very, very proactive when this happened and were seeking some answers and some help and to have whatever they could do happen, he said, listen, your son is so open and honest and willing to get the psychosexual treatment that will be helpful. We recommend that. and that's going to be in my report. However, before we do that, we need to deal with some of those psychological issues that might have happened and that might have been the delay and that might have been caused by the concussions. Now, has most of that been said in the report? It has. There's a lot more information that we've obtained because we've followed up on that, and we've gotten him in that treatment, and he's now been doing that treatment that has come a long ways in helping him, understanding that, medications, doing other things that are going to help him, and he's ready to start that process of the sex offender treatment. Just so this court's aware, we tried to also start the sex offender treatment long ago, but we've been told, and this court's well aware of this, we're so lacking in services in Southeast Idaho that the only room that they have for people are people who have already been adjudicated. Blair Gardner has retired. He used to be a close enough colleague of mine that we worked with for so many years that I occasionally could luck out and call him with a case, and he could find a way to work someone into the treatment who hadn't been adjudicated. But that just is not an option for us anymore, Judge. But what is important is Dr. Lesotho has indicated that it would be important for Teagan to receive the kind of help that we've already had him receiving before he receives the help of the psychosexual recommendation for the treatment that's provided there. By the way, let me point out, and I think this is important for the court, for the public, and the prosecutors are well aware of this. My client's diagnosis is not that he suffers with pedophilia or those kinds of things. In fact, if we put this on a scale and a level, he's way over here in an area that's so treatable. And I know that's hard to talk about because none of this is good that we're here for the reason we're here for. But there is a scale, and he is on the light end of the scale. Now if I just can start to wrap up here, that is consistent with his LSI score, which is very low. I know this court sees low LSI scores many times in cases like this, because sometimes this can be someone's first foray into a criminal setting. But I think if you look closely at the low risk and the assessment that Dr. Lesotho did, the clean polygraph, the issues and medical issues that we've been dealing with and getting on top of, the scenario of no criminal history, the idea of how long this lasted, how it was accessed, not through his own searches, not through a search engine, not through the dark web, not through so many things that you see from so many others. Even from good young individuals that I've had next to me, we have seen those mistakes, and there's mitigating factors with that as well, but I've never had a case like this. So, Judge, in my mind, there is a distinction between the other cases where you have placed someone on a rider and Mr. Swanson. Now, am I full of wisdom? Do I know the right thing to do? I do not. And I trust this court's judgment. This court knows that. I've known this court for a long time. I know how thoughtful you are and what you look at to prepare for these things. If this court determines that a rider is what is right for my client, he is going to go and do that. I think he will be successful. I think he is a candidate now for probation, but I understand if that's what the court feels is necessary, he will do that. We are hopeful, however, because of some of the differences and some of the explanations and some of the hard work that's been done by this good family and by their son, that this court might consider that this may be the one in 100 cases that deserves a serious consideration for probation. That's really how I've looked at it. If we look at recidivism rates, this court's well aware that if we send a young man like this to prison, the recidivism rates are higher than if we place them on probation. I think a rider's a little different. We see better recidivism rates there. But we actively know from Dr. Hatzenbuehler and others, and I know you've heard their testimony, that the recidivism rate for something like this is very low. In fact, I think it's under 9% if we have somebody actively in supervision and if we have someone who is willing and has been given a diagnosis of low risk to the community like my client has by Dr. Lesotho. And if somebody's willing and has shown the, I guess, fortitude to move ahead on their own. My client has been on supervision for over a year now. He's done excellent. He's sought the health care. He has sought the counseling. And he's done what has been asked of him. I think those even reduce the risk to the community more so. And so it's with that, Judge, that I submit this young man to your hands for sentencing, with the hope that we are somewhere in the realm of probation to a rider based on his honesty, his polygraph, his exams, his health care issues, his family. And I would add one last caveat. For the first time maybe in his life, he has met a young lady who happens to be LDS. She's a returned missionary. She's very mature. They have been dating. She knows about his situation. My client's parents say that they have never seen him completely feel for the first time that his life is completely on track. He's been motivated. He has been working. He's been doing his counseling. He's been doing his treatment. He's been doing a very proactive, healthy dating. Those are things that, as you see in the report, he was stifled from. Primarily, we think, some organically, but some because of the concussions. You have all of this in these reports. Does that mean that he gets a pass for what happened here? No. But when you consider the four related goals, he has stability, he's on the path of rehabilitation. I think we can honestly say that protection to community, if he's placed on supervision with treatment, is answered. There is still retribution, there still is punishment, there still is deterrence. This court knows how I feel about deterrence. I do not believe that a sentence necessarily deters anybody, because I think when people commit crime, that's not what's on their mind. However, I'm not naive to the fact that it is one of the related goals that this court has to consider. But if you consider the related goals, I think that what we're asking for with a straight face, a consideration of probation, is well within the realm based on the circumstances that we've given the court. I also understand that prison is in the realm. I don't discount the serious nature of this, but we're hopeful that this court will feel that we are somewhere between probation and retained jurisdiction. And with that, I would submit, and I'm happy to answer any questions if the court has.
You know, Mr. Smith, I typically don't ask questions, but I do want to ask a question in this case, because I have read this multiple times. This is a difficult case. On page 6 of the psychosexual evaluation, it talks about, and this is one of the things this court has struggled with, it talks about, I'll just read the paragraph, I know you may not be able to find it. So it's 3 up from the bottom. It's about the investigation. So they discussed the 3 CSAM videos and the cyber tip that were uploaded to Kick. Swanson admitted he would receive the links from groups on Kick he was on, and even said he would then send the links back to the group. So it wasn't just the download, it was also uploads of those videos. And I don't believe there's any evidence that he created them or stored them or had them. However, the court is struggling more with the thought of, it's one thing, and because I do believe people can inadvertently stumble onto these things. I think it happens. However, this appears to be more download and upload, more of an exchange of things, even though I don't believe that, like I said, I don't believe in any way that he had any involvement with creating or any of that, but there was some discussion, at least in there, about him sharing these. So I just wanted your thoughts on that before I turn over this.
Judge, it's a fair concern and a fair question. Let me try to address it in this way. First of all, my client would accept full responsibility and tell you that he did.
Oh, and he did at the time. I'm not discounting.
No, I know. So I start with that fact, though, but I also do this and say this. The interesting thing about that is we don't have a good answer for why he did that, because it didn't benefit anyone. If you're looking at benefit being receiving something new, one of the things that's different about his cases, and this court knows this, and I think this is why you're asking the question. Many times I've been here before you with clients who've gone out, found new material, uploaded that, and shared that with a group. So you're sharing new information to that group. That's not what this young man did. He simply passed it back to the group where he had received it from. It had nothing new. Might it have hit some new users within the group? That's a question I asked law enforcement that couldn't be answered to me. So nobody can really answer whether he shared it with somebody who had not already received it the first time, but he did bounce it back. And it wasn't new material, it was the same material. But that is a legitimate question and it's a concern. I guess the thing that I still am baffled by, and he probably is too, there was no good reason for him to do that. He hadn't gone out and found any new information and sent it on. And he hadn't deliberately sent it to somebody that he thought hadn't already received it. So that's the best answer I can give you. One of the things that's interesting when I'm involved in this case, I try through law enforcement and through the discovery to determine as much as we can about that. And what I've been told is that there is no way of them knowing whether someone new received that information. But they do confirm that he had not found new information and sent it on. So that's how I would answer that question.
Thank you very much.
Thank you.
Mr. Harris, kind of state's recommendations.
Your Honor, the questions, some of the questions, I guess, that have been asked are questions that I've asked too. This case presents a case where you've got a young man with no criminal history prior to this incident. A young man that comes from a good family, good background, nothing horrendous that we've heard of. More often than not, we hear of people that are here. Well, they're here from their own choices, but those choices were early on manipulated by drugs, physical, sexual, mental abuse, mental health issues. Here we have a young man that looks like your next door neighbor, and to some extent, as given to us by counsel, might as well be his next door neighbor. So a good young man with good family and lots of pro-social contacts and support, family, friends, work. Things look very bright for Mr. Swanson. And so it's very easy for me to even see this, and to some extent you get a cynical outlook when you see this day in and day out, but even for me to look at this as a one-off, a mistake, and something that you get a redo and you don't do it again and life goes on. I would hope that's the outcome. I would hope that's the truth. But there's still some questions. I'd note that, as also mentioned by Mr. Smith, that the pretrial report gave a generally good report. There was a single question that I had in that report that Mr. Smith answered. We then, from that point, go backwards to a defendant in Mr. Swanson who has a very low LSIR of 8, meaning that as far as recidivism goes, it's likely, again, a one-off, something that may never happen again. I know that the plea agreement, in it, the state, I'll go ahead and look at it really quickly, but the state is going to recommend no worse than a rioter, I think was the agreement. And we'll keep with that, and we'll recommend no worse than a rioter. But how we get there, I would note that there's a couple of things that bothered me. When I looked at the PSI investigator's recommendation, and I'm going to read that, the recommendation was for, I recommend that Mr. Swanson be sentenced to incarceration, and as part of that incarceration included sex offender treatment, other programming deemed appropriate, and cognitive behavioral therapies. Also complete a GED, and other recommendations from the psychosexual evaluation. I wondered if that was too harsh, to be honest. I thought, my goodness, no history, first time, that's a pretty harsh approach to what could have been an errant download. And I wondered why that was the case. And I believe the answer to that question's been supplied, not only by the investigator, but also in today's conversation. The issue that the investigator had was that Mr. Swanson, it seems, was deeply ashamed that he was caught viewing child pornography, but was rather detached from the concept that the children were victims that were being forced to engage in sex acts at very young ages. We even had a question about forwarding such images to other people that you don't know how their level of participation in that whole, I guess we'll call it seedy world. We don't know how entrenched they were or were not, but that they were forwarded information. And that, to me, I think, is why the recommendation from the PSI investigator was so harsh. It was like, as a kid, trading baseball cards. Even though no new cards were created, it was not seen as anything more harmful than that. And I believe that was probably why it received such a harsh recommendation, because there needs to be time to learn that it was far more than that, that there were victims. Even though we may not know their names or their ages, whether they be from, I think, as early as 11 years old to 14, we may not know them, but they were victims. And I believe that's why that recommendation came. And I would note that in dealing with some of the statements from Mr. Swanson, he said that at one point he found himself with a lot of time online because he was using his phone as an escape from some of the problems of life. I hope that through programming, I know that the psychosexual recommended the type of counseling and programming and therapy that he's currently taking part in. I hope that he can get to a point where he won't need that escape, because, of course, the problem is with that particular escape, you run into exactly what he ran into, and you run into it a lot more often. With that said, I really had a very short write-up here because, again, he has no history. A lot of the things that I look at in a lot of other criminal situations, Mr. Swanson doesn't have. I just hope that he at some point, through the therapy, through whatever, gets the empathy for victims that I think should accompany such a crime, as opposed to just shame for being caught. And I will keep with the state's promise, which is that I recommend 4 years fixed with 6 indeterminate and a rider. And that's going to be the state's recommendation, with a request for 30 days to file a motion for costs. I don't know that one has been filed. I don't see one in my file. And so we request that 30 days. And I would submit. Thank you, Your Honor.
Your Honor, there's just one small brief thing that might be helpful, because I appreciate the comments of the prosecutor. But on this minimization, I think this is an important part. Dr. Lasoya, and I don't know the page, but it's under demonstrative level of insight. He says minimization, although a concern, speaks more to Mr. Swanson's general psychological functioning rather than reflecting potential attempts on his part to do so purposefully. And I think, again, we're back to anyone who has to have counseling learns more empathy towards victims, and we know that's part of what has to occur. But I think that the actual report itself deals with that some of that disconnect has to do with some of the issues we talked about. And I would also point out that I think in his interview with the pre-sentence investigator, they're short, they're about 30 minutes long. And I think what he was trying to emphasize to her is he loves his parents and he knows that he has put the family through a lot. And I think his focus at that moment was talking about that. It wasn't in exclusion of the victims. I think he understands that as well. But I think that in that moment, his focus was more on how he recognized that this has been devastating to their family and he's sorry for that. But I would just point those two things out on minimization because I think there are some answers there in both reports to that. And with that, thank you.
And I did look, that's on page 9 of the report, I know the section you were referring to, and you quoted directly from there, so
Yes.
the court was aware of that and considered that minimization discussion. So
Thank you.
Swanson, party non sentence in this matter, I give you the chance to address the court. You are not required to say anything, nor do I hold it against you in any way if you choose not to. However, if you do wish to address the court, I give you that opportunity, and once again, you can microphone for our court reporter.
I'd just like to say how sorry I am for what happened. I can promise that won't happen.
Thank you. Are you done? I didn't want to cut you off. I apologize. Is it- Swanson, are you satisfied with the representation of your attorney? Yes. Mr. Smith, is there any legal reason why she's not sentenced?
There is not, Your Honor. Thank you.
Mr. Swanson, based on your pleas of guilty, the judgment of this court that you are guilty of 3 counts of possessor access to child pornography, sexually exploited material. I have carefully reviewed the record in this matter. I have read through the pre-sentence report, the psychosexual evaluation, and listened to the argument of your attorney, listened to the argument of the state, listened carefully to your statement as well. I think that your attorney's done a good job kind of laying out where we're at. And these are terrible cases. I've said it before and I'll say it again, this is a plague on our society. And with the internet, with the way that the world works, people access child pornography that 20 years ago would never consider doing it. 25 years ago, you had to go to good lengths to do it. Now, as happened in this case, consent to it. And like I said, that's what this court struggles with, because I do think that people inadvertently find this type of material. The part that I think, and I asked the counsel this, more concerning was the continued looking, the interplay, kind of the sending back and forth. Because this court has the obligation of considering what to do in the sentence in light of the objectives adopted by the Idaho Supreme Court. And I consider these in all criminal cases, but like I said, in this case, this is one of those cases where I have to consider protection of society. I have to see to the deterrence of you and of others. I know your counsel's opinion on that. However, I am required to consider that by the Idaho Supreme Court. I have to consider the possibility of rehabilitation, and I must see and consider punishment and retribution for wrong. You're 25 years old. I appreciate your counsel's discussion about the concussions. I recognize that all of the information, the training that I've received for the last 30 years talks about the male brain developing slower, and that injuries, we see that through football, we see that through other kinds of injuries, that can have an effect. It can either slow the process down. And I'm not saying that you're going to permanently have these issues. I just think it can slow it down, it can affect it. And you just have to recognize the deficits that may be there. But I appreciated your counsel kind of highlighting that and explaining that. Both sides, both the state and your attorney talked about good family support. At your LSI, what that means is the risk factors that this court looks at are very low. And I firmly believe 100% when you say you don't want to do this again, you don't intend to do this again, that's believe that. And I, like I said, I think from your behavior, I think that's true. think it's very clear that there's no allegations or evidence of any kind that there was anything other than watching the videos or looking at things. There was no contact review, anything other than that. And I was struck, frankly, when the state said this could be your next door neighbor. And that's why I call this a plague on our society, is because it can be. It can be somebody who you know and is a good person and has a good family. And sadly, I've seen that, and I see it in this case. I mean, when I look at your substance abuse issues, which is very rare on this type, not on this type of case, but very rare, frankly, in criminal court. No alcohol, never used substances, gainfully employed. I struggle a little bit with education, but I think all that does is kind of lend credibility to the argument that your attorney makes, that some of those issues that may have happened with traumatic brain injuries, with concussions, kind of created some of those issues. So like I said, you have gainfully employed, you have a supportive family, and as argued by your counsel, family that contributes to society. I read all of the things that your counsels argued, or everything the state referred to, where it talks about on page 8 of the pre-sentence report that you're deeply ashamed about viewing the child pornography. I recognize the argument about the detachment, and I think that it's not uncommon for people to take some time to realize that those are children that are being abused, and you're watching it. I recognize that it takes some time sometimes to understand that and fully develop that, especially when someone is younger. In this case, you're 25 now, you were 22, 23 when this was going on. But I'm also mindful of what those videos were. And when you talk about the ages of those videos and the pictures, infants, 3 to 5 year olds, and that listed out on page 7 of that psychosexual evaluation. And they're bad videos. They're terrible. They're horrible. They're disturbing just reading the description, not even watching it, not having, And so this court has to balance out all those factors. There's a criteria that's scheduled set forth out of Code 1925-21 when I consider the factors having to do with this. I think that with the right treatment, the likelihood of reoffense is low. I think that being aware more of kind of some of the mental, and I don't say, I think it's described as mental illness, not a mental health issue, but more just a recognition of perhaps some of the traumatic brain injury that's occurred. Do I think they're so? If I do I think that you're a bad person? I don't. I think you're made a mistake. I think that mistake continued, and that's, like I said, I asked that question to counsel. I continue to struggle with that because it did continue. It wasn't like you saw it once, you were automatically repelled by it. To be that got out of that group and never went back. You engaged in and continue to engage in that, and ultimately had 158 different things. So I consider all of these factors, and considering where you are, it's going to be the judgment of this court that you be sentenced to custody out of the Department of Corrections as follows. This is for all 3 counts. It's my intent to run them concurrent for a minimum term of 2 years, followed by a term of 8 years for a total of 10 years. That will be on each count, running concurrent with each other. A fine in each count of $500. Standard court costs, payments in the Victims Relief Fund will allow the state 30 days to file restitution. I considered probation. I assumed your counsel be arguing for that. I considered that. The pre-sentence investigator recommends prison. I agree to say that it's too harsh. However, I think to do anything other than retain jurisdiction in this case, not place you immediately back on probation, I don't feel like I would be treating this with the severity that I need to, with the seriousness that I need to. So I will retain jurisdiction in this matter, since I'm the writer, for 365 days. How that works is you take custody. There will be sent to one of the facilities. Will receive a report about a month before you finish with that program. If you've done well at that point, I'll consider bringing you back to probation with some of these factors and considerations that have been argued. I anticipate you doing well, otherwise I wouldn't do it. I would have just sent you directly to prison. I frankly have a lot of hope for you, sir. I really think that you can, as described by the state, see the mistake, correct the error of your ways, and move forward. I will give you credit for the time you've served up to this point. And the advisor has the right to appeal to the Supreme Court for this judgment of conviction. You have a right to represent a minor during that appeal if you cannot afford one. One will be appointed for public expense, however, you only have 42 days from today's date to do that. You also have the right to seek relief under Idaho Criminal Rule 35 if you feel the sentence was illegal or unduly harsh. You have 120 days for that. You also have the right to seek relief under the Idaho Uniform Post-Conviction Relief Act. Such an action is filed in 1 year from the date of conviction. Questions about that? Please consult Mr. Smith. I will order a question of the meeting stamp on the right as well. Consistent with that. Anything else to add to this matter, Mr. Smith?
Your Honor, I don't. I know this is a tough ask, and so I understand the court may not be able to do this, but we've had a case or two where we have allowed someone to stay out pending transport for the retained. Just based on some of the things in the report, I've wondered if the court might be willing to let that happen. He's in a very stable environment with his parents, very responsible. I know it's unique. We used to do it often. It's not something we do often now, and I don't ask for it often, but this is a case that I felt like, based on the reporting, that I would. We understand whatever your decision is, we will honor that, obviously, but I would make that request if possible.
And deny that. The instructions that we receive is that it just delays it, that if he's not there and available, then we just delay. And I think at this point, I'd rather have it done sooner rather than later.
I appreciate that. I assume the court, if we monitor that and he's sitting too long, we certainly can deal with that issue. Appreciate that. Thank you, Judge.
Anything else, Mr. Harris?
No, Your Honor.
Good luck, sir, with being recent.
Appreciate it.